the importance of updating our legal documents as you age. You know, couples get divorced, family conflicts arise, there's health issues can occur over time, and especially cognitive-related diseases such as Alzheimer's or dementia-related diseases as well, and estate planning, financial issues. It goes on and on and on. Well, let's bring in Notary Nadia De Riggi to help us out. Nadia, welcome to Life Unrehearsed.
Thanks, Matt.
Well, thanks for joining me. We do have to update our legal papers as we age. It's, every so often you need to do that. Things change in life and we tend to forget it. And almost more than 50% of Canadians don't even have a will. It's just staggering statistics. So, Nadia, why is it important to have a will?
Well, I think there are so many reasons why having a will is important, but what really stands out is the word control. So, maintaining control over your affairs, being able to make decisions ahead of time regarding your property and your loved ones. With a will, you're going to get to decide who's going to inherit from you, how your property is going to be divided, in what percentages, who will act as your liquidator. Also things like what happens to your sentimental or valuable property. So it could be really a helpful way to make those decisions ahead of time. It also helps your heirs receive their shares quickly. It reduces unnecessary conflict and legal costs, delays. So we want to minimize all of that when we're thinking about writing our wills.
Absolutely. Extremely important. And not only writing the will, but updating it as well. Things do change. And Nadia, there are several different types of wills. It can get a little confusing. Can you sort of straighten us out here? What are the different types of wills?
Certainly. So in Quebec, we have three types of wills that are recognized under our civil code. The first is a notarial will. So this is a will that's prepared by your notary. And what's nice about this type of will is that it doesn't require probate after death. So probate is verification. And it also offers you the highest level of security and clarity. And the second type of will is what we'll call a holograph will. This is a will that's entirely written in your own handwriting and signed by you, but it requires probate after death. And then we have the third type of will, which is a will made in the presence of witnesses. So this, similar to the holograph will, would be signed by you, but it can be typed or it can be handwritten, and it's signed in front of two witnesses. So this also requires probate after death.
Right.
So generally speaking, the notarial will is the most secure and the easiest to use.
Right. People will tend to think, but it might be more expensive in the long run. It really shouldn't be a cost equation here. It turns out to be, after probate, and very often more expensive. In notarial will, I see that a lot. Most families are choosing that. I'm glad you mentioned that. Listening to Life Unrehearsed, Matt Del Vecchio here. I'm talking to Notary Nadia De Riggi about the importance of updating our legal documents. Nadia, one of those legal documents is called an advanced medical directive. What do we mean by that?
Yes, so I get this question a lot. So advanced medical directives are written instructions about medical care. So things like treatments that you accept or refuse should you become incapable of giving consent. So you're giving that acceptance or that refusal in advance or in anticipation. Advanced medical directives apply to specific clinical situations. So things like being in a coma, late-stage dementia, end-of-life situations, or serious and irreversible medical conditions. And these directives will help ensure that you receive the care that you want, suffering, but also relieve loved ones from having to make those decisions during a crisis. So it's in an effort to relieve our loved ones, to reduce family conflict or confusion in a time where it's very, very difficult to make these decisions.
Very good point, Nadia. It is emotional. Usually you're not thinking about it until something happens, and it is crisis mode. Advanced medical directive. We could all do it here in Quebec. It's actually very easy. Just Google or search advanced medical directive. You could fill out a form with the government of Quebec, and it'll all be registered right there. Nadia, we're going to switch again. A lot of legal documents. What is I get this question all the time, the difference between a power of attorney and a protection mandate, and should you have both?
So I'm going to start by saying, yes, you absolutely should have both. They are very different, so it's often They're often confused for one another. Power of attorney is a document in which you appoint somebody to assist you with administering your property and your finances, and it could be used immediately. So with this power of attorney, you could give general powers to somebody or specific powers, to take care of banking transactions or bill payments, dealing with government agencies. Whereas the protection mandate is slightly different. It only comes into effect once you're declared incapacitated, so not upon signature. It's got to be homologated, or it's got to be recognized by the courts to be used. And it covers not only property administration, but also your personal care. So with this document, we're not only talking about who's helping you with financial management, but also who's helping you with medical decisions, living arrangements, long-term care decisions, and access to medical records. So it's much broader in scope, and it protects you when you're no longer able to represent yourself.
Talking with Notary Nadia De Riggi about the importance of updating our legal documents. I'm going to dig a little deeper here. The protection mandate, it makes sense what you're saying. The power of attorney, certainly help you out and pay bills. But a protection mandate is you're saying your wishes while you are apt, but it only works, I guess, once you become incapacitated. And you use this sometimes confusing word called homologation, which is the method to whatever you put in writing in that protection mandate, that now you have to make it become real. So can you explain what homologation is and how it goes about?
Sure. No, so it's exactly that. Homologation is the legal process in which the court will officially recognize your protection mandate once you have become incapacitated. So the way it works is we have evaluations done, so medical and psychosocial evaluations to confirm your incapacity. Then we're going to notify your interested family members. We're also going to notify you that we are going through this process. And we're going to confirm with the person that you've appointed in your mandate that they wish to act on your behalf, so that they are willing participants in all of this. So all of that is filed with the courts. And it's done in an effort to protect the vulnerable person and to ensure that your wishes are being respected if you're in that vulnerable situation. We're also ensuring that the person you've appointed is in fact ready to take on the role. So without homologation, unfortunately, the mandate cannot be used.
Right. So important. Get that power of attorney, get that protection mandate. And again, we can't assume just because we have that protection mandate and it's in writing, you actually have to homologate it for it to become real. A lot of information, Nadia. Thank you very much for enlightening us. Really appreciate it. How can our listeners get a hold of Nadia De Riggi?
By phone, always the simplest way, 514-484-2788.
I'll repeat that. 514-484-2788. Is that right?
Yes. Thank you, Matt.
All right. Well, that's Notary Nadia De Riggi. Thank you very much for coming on the show.